Welcome to Senate Corporations. Our good Chairman Driscoll will be here shortly. He is in another meeting this morning, so I'll go ahead and get us started. Roll call.
Senator Boner.
Here.
Senator Case.
Aye.
Senator Senator Nethercott.
Here.
Senator Scott. And Chairman Driscoll.
He'll be here shortly, so he's
Okay.
excused for now. Well, good morning on this Tuesday. You can tell we're all sharp and ready to go on this second week being live here at the Capitol. We have first in our agenda Senate File 126, Real Estate Subdivision Easement Requirements. And I see that is sponsored by Senator Cooper, but I don't see Senator Cooper. Has anyone seen him this morning? All right, seeing that he is not here, we'll go ahead and lay that bill back for a moment and we'll go to Senate File 38 from a brilliant committee known as the Select Committee on Blockchain, Financial Technology, and Digital Innovation. Who would be the brilliant members of that committee? Senator Rothfuss? I think this morning we're going to start out with a very easy and simple bill here with decentralized autonomous organizations. A simple 17-page bill. Chairman Rothfuss of the Blockchain Committee, welcome to Senate Corporations. It's wonderful to see you. For those of you who don't know, I also serve as a member on that committee as well, and so familiar with the DAO, which I'm excited to hear about this morning. Walk us through this fine little bill, if you could, Chairman Rothfuss.
Thank you, Madam Chairman. Madam Chairman, we'll be joined shortly, I believe, by Mr. Kaufman, who is a member of the committee as well, to help us with the legislation. And we have some experts that, if they haven't already joined us, they should be online fairly soon. And I check in to see if Mr. Aaron Wright or if for some reason Mr. Kaufman is online, because they would be helpful in actually walking through the bill as well. So I'd ask if we've got either Mr. Aaron Wright, there's Mr. Aaron Wright. And I think Matt Kaufman is going to be here in person, if I'm not mistaken. So I don't expect him to be on there, but if he is on there, let's let him in too, if we may, Madam Chair. No, I think he's going to be here in person. And Madam Chairman, if we can, I defer just for a moment to Mr. Wright to introduce himself and let him provide a little bit of background on decentralized autonomous organizations after I give a brief overview. Mr. Wright worked with Mr. Kaufman from our committee, and this was the nexus of a working group that was formed to address decentralized autonomous organizations and help draft and craft this supplement to our limited liabilities corporation statutes. And to provide a little bit of overview, and we'll get to Mr. Wright in a moment to provide a little more detail. This is actually what he studies in the course of his work in law. A decentralized autonomous organization is a new concept, and this is one of the flagship bills that's really coming from the Select Committee on Blockchain, Financial Technology, and Digital Innovation Technology from the interim. Mr. Kaufman, please feel free to join us if it's okay with the committee. This is a new concept for organization and management of a corporation that has an incredible amount of demand and an incredible amount of interest from the private sector. But it's new, it's different. This is, we ran last time I joined you legislation related to a B Corp, which many other states had done, and we looked around and tried to find the best standard for that. This is exactly the other side, and this is more consistent with what we've typically seen from the Blockchain Task Force and Select Committee. This is the first of its kind. This is the first time in the United States, or probably in the world to my knowledge, that legislation to specifically provide the framework for governance of a decentralized autonomous organization is being put forward. These already exist, but they've typically been crammed into some other type of corporate framework that really doesn't fit or contemplate their governance structure. And the idea here is to have the primary governance of this limited liability corporation. And we can talk a little bit about why we chose the LLC model instead of a C Corp or some other type as our starting point. But it is largely or fully autonomous in that smart contracts and computer code govern the corporate operations of the company. And this is something that's already done right now. But again, it doesn't fit well within the parameters that other corporations utilize. It's done in development of code. So computer developers that work together and form sort of a coalition of open source coding. They want this collaboration. They want some corporate protection and governance, but none of them are the CEO type, so to speak. They write code. So they want their CEO and their board of directors to be the code. And they want to get back to coding and perhaps hiding in the basement where they code or wherever it is under fluorescent lights, as the case may be. It's hard to say. And do the work that they do best. And this then is our work during the interim through the working group to bring that forward, advance it, and to provide a framework, a structure, so that there's legitimacy to it, so that the courts know how to handle it, so that as we have any potential conflicts or challenges, we know what to do with it. And I'll pause there, and I'd like Mr. Wright and Mr. Kaufman to introduce themselves to the committee and talk a little bit about the work. It wasn't just the two of them. We have had an incredible team that has come together, including Professor Moxley from the University of Wyoming as well, other experts, professors, lawyers from around the world and around the planet to work on this and try and get us to the point where we are today. So with that, Madam Chair, I'd pause and allow an opportunity for Mr. Kaufman and Mr. Wright to provide a little bit of background on themselves. And then I'd ask as a way to move forward that Mr. Kaufman walk through the bill as we did last time and discuss why each provision is laid out along with help from Mr. Wright as we provide some context for this supplement to the LLC statutes in Wyoming.
Chairman Rothfuss, thank you so much. Mr. Kaufman, welcome to Senate Corporations. It's good to see you again. Just for some clarity and big picture concepts, just to help orient us here this early Tuesday morning, this bill creates kind of a new corporate status. Is that fair, Mr. Kaufman?
Yes, Madam Chair. As Senator Rothfuss said a moment ago, there's nothing really keeping a lot of these entities from doing this now. They just sort of, again, square peg, round hole into an existing LLC structure. This would be the first statutory structure to create a way for them to do this cleanly. I don't know that it necessarily, one way to characterize it would be that it's a new corporate structure. The way that the bill is designed, though, is as a supplement to the LLC Act. So much like we have close LLCs or close corporations, this is designed to be a supplement to the LLC Act as a subtype of the LLC.
Thank you, Mr. Kaufman. That's very helpful. You want to walk us through the bill?
Sure. And
Senator Scott is formulating his question. And I just want to welcome everyone. This is the committee of chairmen. And so there will be an aggressive line of questioning.
So, Madam Chair, before I do, again, my name is Matt Kaufman. I'm an attorney with Hathaway and Coons here in Cheyenne. I'm also a governor-appointed member of the Select Committee. Also is Aaron Wright, a professor at Cardozo Law School back in New York. Mr. Wright and I, along with a number of others, have taken the lead on putting this bill together. We've had quite a large working group with input from a lot of folks. The product that we've arrived at, we feel pretty good about. And with that introduction, I'll begin walking through the bill. So again, as I was just saying, we'll start with the short title of the bill. The bill is to be known as the Wyoming Decentralized Autonomous Organization Supplement. Again, a key distinction that this would essentially be a subtype election that you would make on an LLC filing. We can go through the definitions very quickly. Obviously, this legislature has already taken great lengths to define what a blockchain is. A decentralized autonomous organization means a limited liability company organized under this chapter. Again, the legislature has also done a really good job of setting forth definitions for what digital assets are in this state. Something I might add from my law practice perspective, we spend a lot of time talking about these days, and a lot of folks across the country have taken note to the way that we have defined digital assets. It's becoming a very useful definition. Couple of other housekeeping definitions. We define what a majority of the members is. In this case, standard definition will be 50% of the participating membership interests. A membership interest is just that, the same as a traditional LLC. It's a member's ownership share in the decentralized autonomous organization, which can be defined through the articles, a smart contract, or the operating agreement. The definition of an open blockchain, again, this legislature has defined what an open blockchain is, but that is a publicly accessible decentralized ledger. We define quorum, self-explanatory there. And then the last definition important for this is the definition of a smart contract, which is an automated transaction. We've already defined that in Wyoming statute, but it's comprised of code or script or programming language that executes the terms of the agreement essentially on its own. And there's a lot of forms that these smart contracts can take. Mr. Wright is quite the expert on this matter, so I would defer any questions specifically on the smart contract operations to him. But essentially, I think of, in my simple lawyer brain, of a smart contract as an if-then statement. Think about it as an if-then statement in an algorithm. If this happens, then this happens. And using digital assets, you can create these entities and essentially pre-program the operating agreement between the entities so that if certain things happen, then that transaction is initialized or self-executed even. And so it's a very, very efficient way to do it. It requires, in this case, and we'll spend some time talking about this, but it requires these entities to be member managed as opposed to manager managed. Recall that we have two different types of LLCs in Wyoming, the member managed and manager managed. These entities are designed in theory to be decentralized. That is, the members as a whole participate in their management and participate in their function. So they really can't be manager managed. So just wanted to set that context as we go through this, that they're designed to be member managed. Starting now on 1731-103, the application of the LLC Act as we have. Again, the LLC Act applies to this new subtype of entity to the extent not inconsistent with this subchapter. So again, from a legal perspective, we would use the principles of the LLC Act to supplement any legal issues that might arise under this subtype of LLC, except where this new sub-act is specific. This chapter is not intended to repeal or in any way modify the LLC Act. Senator Rothfuss can attest to this fact. We were quite vocal in our committee about protecting our LLC Act. We have a phenomenal LLC Act in Wyoming and one that we're proud of. So nothing in this act is designed to change or affect the LLC Act as it stands. Moving on page, on mine, it's page 5, 1731-104. So this is the definition of election and decentralized autonomous organization status. So to save time, I'll refer to it as a DAO. The DAO is, again, a limited liability company. You have to elect such in your articles of organization. An LLC that is a DAO has to be formed via this mechanism only. There is a mechanism to convert an existing LLC, but that would require a restatement of the articles. And with the articles filing, an entity would have to make public what blockchain it's operating on or what that smart contract protocol is that they're operating. It's, senators, you might recall our conversation about a week ago on the public benefit corporations. Again, we're taking a serious approach to notice in this case, that folks that are getting into these type of entities understand what they're doing, that they realize what they're doing, and that those protocols are made public so that they can access them. Subsection C, again, these DAOs have to have a statement in substantially the following form that's conspicuous on the articles. It has to state clearly that it is a decentralized autonomous organization. that it may reduce or eliminate fiduciary duties of the members. It may restrict transfer or ownership of interests, withdrawal or resignation, return of capital and dissolution. All those types of legal issues that as a member of an LLC you're concerned with. We want people on notice that a DAO may operate differently than a traditional entity. Obviously, the name designation, we are specifying that these DAOs have to have that terminology in the name. DAO, LAO for limited autonomous organization, or a DAO LLC. There has to be some designation again to put the public on notice. There has to be a statement in the articles that define the DAO as either a member-managed decentralized autonomous organization or an algorithmically managed decentralized autonomous organization. And there are some subtle distinctions there. And again, I'll defer some questions on how the algorithmically operating entities to Mr. Wright, who again is an expert in this field. Now moving on to 1731-105 with respect to formation. So again, similar to a traditional LLC, one or more members can file the articles and initiate one of these types of entities. Subsection B, each decentralized autonomous organization has to have and continuously maintain a registered agent, just as any other entity would. The DAO may form and operate for any lawful purpose, regardless of whether or not it's for profit. So again, consistent with the traditional LLC Act. And an algorithmically managed DAO may form under this if the underlying smart contracts are able to be updated, modified, or otherwise upgraded. That's one of the restrictions that we placed because there are projects that exist out there in the blockchain world where someone has started an entity or some sort of a smart contract and fails to maintain it. We don't want to give those types of entities or those types of projects limited liability status. So we're setting the bar high here that these have to be maintained projects to qualify for this status. 1731-106 gets into the specifications of the articles itself. So obviously the articles have to include a statement about being a DAO. The articles have to include the publicly available identifier of any smart contract being used to manage or facilitate the DAO. Again, getting back to that notice conversation, making sure that people are aware of what the protocol is that's operating this entity. Subsection C, except as otherwise provided, the articles shall govern all of the followings. Relations among the members, again, consistent with the underlying LLC Act. The rights and duties of a person in their capacity as a member. The activities of the DAO and the conduct of those activities, the means and conditions for amending the operating agreement, the rights and voting rights of members, transferability of membership interests, withdrawal of membership and distributions to members, amendment to the articles, procedures for amending, and then any other aspects. We kind of have a catch-all in there. I will tell you that, and we don't have the ability, I think, or the time to do this today, but it would be fascinating for you all to see how one of these entities operates. I've had the privilege with Mr. Wright of a DAO that he's a member of going to the dashboard, for that decentralized autonomous organization and seeing how the members interact and how a member can essentially put into this protocol a call for a vote on something or a proposal for an investment or a proposal for a change to the operating agreement, and how the smart contracts initiate the voting procedure for the entity and automatically notify members. It's really quite striking. And again, the lawyer brain that I have just flips on when you see this operate. In some ways, it's kind of the way that notice and entity should work. It's pretty impressive. Moving on to 1731-107, amendment or restatement of articles. We require that the articles of organization for a DAO shall be amended when there's a change in the name of the DAO. If there turns out to be a false or erroneous statement in the original articles, or if the DAO's smart contracts have been updated or changed. Again, notice, we want people to be aware of what they're involved in. 1731-108, operating agreement. Again, to the extent the articles or smart contracts do not otherwise provide, the operation of the decentralized autonomous organization may be supplemented by an operating agreement. Again, I would call your attention to the fact this is consistent with the underlying LLC Act. That is, we have default rules for the entity unless the entity modifies those default rules through an operating agreement. No different here. It's just that that operating agreement might exist solely in code. 1731-109, the management section. So management of a DAO shall be vested in its members. If it's member managed, or the smart contract if it's algorithmically managed, unless it's otherwise provided. So again, we don't really leave an avenue for these to be manager managed. They're not designed to be. If an entity has some alternative technology that they want to use to be a manager managed, they can just elect to be a traditional LLC. 1731-110, standards of conduct for the members. Again, unless otherwise provided for, we specify that no member of a DAO shall have a fiduciary obligation to the other members. They still have the covenant of good faith and fair dealing. Again, this is pretty consistent, the theme that we see in corporate law, and that is just by virtue of being a co-investor or a co-member of an LLC doesn't necessarily invoke a fiduciary obligation. You still have good faith obligations and contractual obligations, but we want to be careful about specifying that. 1731-111, membership interests for these DAOs and voting. Again, we set forth that unless it's otherwise provided for in the articles, the smart contract, or the operating agreement, that membership interest shall be calculated just based on the digital assets contributed to the organization divided by the total amount of assets. So it's a pro rata share, essentially. No different, again, than the default rules of the underlying LLC. In this context, we're just anticipating that we're going to be dealing with digital assets. And then the second provision there, if members do not contribute digital assets as a prerequisite to becoming a member, then the default rule is that each member will possess one membership interest and be entitled to one vote. So again, something that can easily be modified by smart contract or operating agreement, but we set the default rule. And then we do the same with a quorum, that the quorum shall not be less than a majority. 1731-112, the rights of the members, managers, and dissociated members. Members shall have no right under this act to separately inspect or copy records. So this is a little bit different than the traditional LLC Act. The reason that this is a little bit different is, again, because the governing critical documents of the entity are designed to live in a smart contract protocol that's accessible by the members. So we don't have a separate obligation on the entity or on a particular individual within the entity that if they receive a records request, they have to respond. We're making it all publicly available in a decentralized fashion. 1731-113, member may only withdraw from a DAO in accordance with the terms set forth therein. If no terms and conditions for withdrawal are set forth, then a member may withdraw only via a vote by the majority of the members. Again, we're setting the default rules. These can be modified via the smart contract or operating agreement, but we're establishing the default. Subsection B, a member of a decentralized autonomous organization may not have the organization dissolved for failure to return the member's contribution to capital. Again, that would have to be, and the reason for this type of provision is that will be governed by the operating agreement or smart contract. It might even be set forth in the articles. What we don't want to do is create a legal mess by anytime somebody tries to withdraw or dissociate from one of these, it invokes some automatic right that doesn't exist in the smart contract. Subsection C, unless the organization's articles or smart contracts, operating agreements provide otherwise, a withdrawn member can forfeit all of their membership interests in the DAO, including governance or economic rights. This, in my mind, is kind of almost an abandonment provision, that if you have people leaving, we want them to understand that, hey, if you're walking away from this completely, you could potentially lose your interest. It's your obligation to stay involved and maintain the membership interest participation. 1731-114, dissolution. Well, let me back up here. A DAO organized under this chapter shall be dissolved upon the occurrence of the following events. So if there's a fixed duration and that duration expires, obviously they would be dissolved by a vote of the majority of the members would be dissolved, again, consistent with what we already have in the underlying LLC Act. At the time or upon the occurrence of events specified in any smart contract, the articles or operating agreement. As an example, a lot of these entities now are existing for investment purposes. So it may be in the smart contract that the purpose of the entity is to make an investment into Ethereum, right? And we're going to hold that for 6 months and then withdraw, return members' capital, and dissolve. Something to that effect. We want that ability to be able to execute automatically. And then by order, I'm sorry, I skipped one, maybe the most important one. The Dow Autonomous Organization has failed to approve any proposals or take any action for a period of 1 year or more. So the purpose of this provision is, again, we don't want these entities sitting dormant. So if someone fails to manage the entity, if someone fails to keep the smart contracts up and operating and it sits dormant for a year, then it triggers dissolution. So again, this is a protection for those members, the people that are participating, that they would have a way to get out. And then lastly, by order of the Secretary of State, if it's deemed to no longer have a lawful purpose. Skipping down to the last provision, 1731-115, simply states that the articles, the operating agreement, are effective as statements of authority, where the underlying articles and operating agreement are in conflict. The articles shall preempt any conflicting provisions. And then lastly, where the underlying articles and smart contracts are in conflict, the smart contracts shall actually govern. The reason for that is, in this case, where you might only have articles in an operating agreement as the two underlying or primary governing documents for an entity, we now are introducing a third, and that is the smart contract protocol. So we have to create a hierarchy there. These entities are designed to be primarily conducted through the smart contract protocol. So we have to give them, I guess, preeminence in that order.
Mr. Kaufman, the room is riveted. We appreciate you affording us the opportunity to get comfortable and settle in the morning. Mr. Kaufman, thank you for that explanation of the bill. Mr. Wright, we're headed your way here in just a minute. The good chairman is also back, but I have a question for you. And these are hypotheticals for both you and Mr. Wright. Under what circumstances do you ever see a derivative action being presented by one of the shareholders? Because it's hard for me to hypothesize or come up with a scenario with the smart contract construct of a DAO for what that would look like. So just wondered if in all of your brainstorming, if you came up with an idea and what that would look like.
So, Mr. Chairman and Aaron, feel free to weigh in here, but understand I'm taking a legal position on something that has never been obviously litigated or considered by a court anywhere in this country or world. I'm not sure that a derivative action could actually be maintained against one of these entities. And the reason is that a derivative action is based on a breach of those in control of the entity violating their fiduciary obligation. That dynamic doesn't exist in one of these entities. So if there's a breakdown of the smart contract, I suppose there could be direct actions by one member against another if there was some perceived, failure in executing the code or drafting the code, but I'm not sure a derivative action is even going to be possible.
I look forward to trying, Mr. Kaufman. Senator Case.
Thank you, Madam Chairwoman. I'd like to back up a little bit to the membership and membership withdrawal. And that's fascinating to me as how you could become a member and then how you can unbecome a member and what that means. I mean, I know what it means in terms of other corporations and things, but also the fact that if there's not an agreement about how that's done, you have to have the permission of everyone to withdraw. And I could see a potential conflict there. But I'm not sure. I'd like to maybe just talk about that a little bit more.
Blood in, blood out, Mr. Kaufman. Would you like to opine?
So, Madam Chair and Senator, great question. I would just draw the distinction again for everyone's benefit to the difference between withdrawal and dissociation.
Mm-hmm.
So a member at any time can say, I'm tired of this. I don't like what's happening. I want to dissociate, which means I'm going to express my withdrawal. It may not be a legal withdrawal, right, or an economic withdrawal of the capital interests, but you can dissociate. We do have, again, default rules set forth in here of what happens if someone dissociates, because What we don't want is for that to result in abandonment of an autonomous organization. Someone has to be responsible for ultimately executing. So the default rule is if you dissociate, you risk, it's not conclusive, but you risk walking away from those interests. Different than letting or notifying the other members of the entity know that you want to withdraw. Of course, we would anticipate that normally that would be covered in the articles or the operating agreement. There would be some procedure for that. All we specify here is that, okay, if you want to withdraw, you at least need some threshold approval by the organization. If you don't have that, you revert to be a dissociated member. It's really, Mr. Chairman, it's really not that different from the underlying LLC Act rules in that respect.
Senator Scott. You ready?
Madam Chairman, I have so many questions, I don't know where to start. Madam Chairman, there's a provision in here on the contribution, which, as I remember the LLC, we still have the default, I believe, that unless they specify otherwise, each member is equal in terms of their ownership of the thing. And this seems like a exception to that. But there's a provision in there that you've got, unless you're making a digital contribution, then you get some ownership in proportion to the digital contribution.
Page 12, Madam Chairman.
Okay, thank you. How do you measure the digital contribution so that you know how much, it's clear who's got how much of an interest?
Mr. Kaufman?
Madam Chair, and I would invite, if possible, Mr. Wright to respond to this as well.
Mr. Wright, we need some backup. If you would introduce yourself to the committee. And if you heard the question, we're on page 12 of the bill. And can you answer the question associated with how the smart contract maintains or values proportional or any type of contribution?
Thank you so much, Committee Secretary Nethercott. Thank you so much for the opportunity to testify and speak today. As noted before, my name is Aaron Wright. I'm a professor at Cardozo Law School in New York. My research focuses exclusively on blockchain technology. As part of that research, I co-authored a book that Harvard University Press published on blockchain law and policy several years back. To answer kind of the more narrow question that was just presented, which is a really fascinating question and a good question as well. The underlying smart contracts keep track of all the ownership interests. So if you contribute, let's say, some amount of a digital asset, your units, your shares, or however else it's kind of programmed in the underlying smart contracts will keep track of it. So you don't have to worry about that as much. And beyond keeping track of it, at least today, everybody else can see what you've contributed, what your interest and ownership is, and all of that kind of cap table management just comes out of the box. It goes back to what Mr. Kaufman said before. In many ways, all this information is made public and transparent on open blockchains. It's visible by other members. It's also visible by the public, and that enables a higher degree of transparency and make sure that everybody's put on notice. It makes sure that there's less information asymmetries, which should ideally narrow the opportunities for fraud or some other bad activity. And at the same time, you can continue to operate these organizations potentially more efficiently. So I hope that answered the question. Thank you.
Senator Scott, follow up.
Oh, well, suppose we've got one of these things and I contribute something that's a whole set of code for, say we're in the business of selling securities, and I contribute some kind of code that does some of that, and Senator Runoff contributes a different kind, and they may do different things, and he says, my contribution wasn't worth half of what his was worth. how do you decide who gets how much, a percentage of the organization?
Mr. Wright?
Yeah, I think these are great questions, and I don't know if there's all the answers to it, but if it's a digital asset, and let's say Mr. Kaufman contributed 1,000 units of one digital asset, and you contributed 2,000 units of another digital asset, there would be a record of that. Whether that solves the valuation questions is a separate issue, but at least you know what the contributions were. You'd be able to see that, and other members or participants in that organization would be able to see that as well. My sense is, and this goes back to some previous comments, this will mostly involve digital assets, at least in the short term, because it's easier to understand pricing. It's easier to keep track of digital assets in a smart contract-based system. And over the longer term, some of the questions that you raised and the challenges and complications likely will begin to be addressed, and they can be addressed in an operating agreement. They could be addressed in the articles, at least as contemplated in the proposed bill. So there's a lot of flexibility to make sure that people do it right, while at the same time, making sure that they can order their affairs in the way that they see fit, and in a way that I think can push forward the way organizations are operate.
Thank you, Senator Scott.
Madam Chairman, I'm starting to see this fundamental difficulty here, because you're going to have ownership interests that are determined in part by your digital contribution. And I can't see any clear rule for how you value differing digital contributions. And I think that leaves the ownership and the voting rights unclear. And I would think that could be a fatal flaw in this. If you get down the road and you've got something of real value here, something worth fighting about, and you're not sure exactly who owns how much of it. You may be sure who contributed how much, but you don't have a common means of valuing it. How in the heck do you deal with the complications that will come up in the business world?
Senator Scott, we call that lawyers, but I will refer to Mr. Kaufman, who is anxious to answer this question.
And Madam Chair, thank you. And Senator, so as an example, Senator, I don't think that that's going to be as big of an issue as you might expect. So, and Professor Wright, please weigh in if I take this off track, but most of these entities would be designed to operate on a particular blockchain, for example. So let's use Ethereum, one of the largest blockchains in the world, as an example. If everyone was contributing Ethereum, the native token of Ethereum, that's incredibly easy to evaluate. If the smart contract enabled that protocol to take contributions of another Ethereum-like token that was enabled on the Ethereum blockchain, that's incredibly easy to value in real time. So I think the circumstance that you're anticipating will largely be precluded by the fact that contributions are going to have to be blockchain specific. And as a result of them being blockchain specific for a particular smart contract and a particular entity, that problem is very easily solvable.
And I misunderstood, maybe I totally misunderstood this thing. I thought that some of the contributions were going to be things like code or things like that. They're not. You're just talking about these digital currencies when you're talking about digital assets. Is that what's going on?
Madam Chairman.
Chairman Rothfuss.
The smart contract technology is very broad and diverse. So at its simplest, certainly managing cryptocurrencies on Ethereum as a response to a blockchain is going to be very straightforward. We very intentionally don't lay out all of the details on how everything should be valued and done because we want industry. We want the folks that are working in this space to solve the problems you're talking about. I don't care what they end up digitizing as the asset in the end, and I don't care what the smart contract says and how they do it as long as it comports with this structure. They might come up with a valuation system for their hours of coding based on who they are and how good of a coder they are. And they could do that in this system very easily through a distributed voting system on the Ledger technology, where everybody basically qualifies and says, wow, Mr. Kaufman, that's some A-game lawyering you just did there. We're going to give you 100 credits. And then we've got a voting process that's part of a smart contract where everybody's queried. More than 50% of the votes come back. It says, yes, we all agree that Mr. Kaufman is exceptional. So we're going to give him additional ownership interest or crypto in whatever space we're doing. Nothing precludes that from happening. Nothing requires that to happen. We've got agreements that are allowed that dictate what those business operations look like, just like you would do with an LLC, where you'd basically have the same thing written down. You know, if you go and move 300 hay bales, I value that at a certain amount relative to doing some work on irrigation. I don't know how or why you value it that way, but I don't need to. And this framework sets up that same type of structure where you have to put a lot in the front end. There's no question, you know, the default out of the box is not going to be able to provide that valuation. But when you set up the member managed agreement or a fully autonomous agreement, you can anticipate that in the articles. You can have the capacity to even change that over time if that's part of the articles and part of the agreement. This is leading edge enough that whatever answers I come up with right now, 5 years from now when we look back, will probably seem silly. The industry and the folks that work in this space will come up with far better uses of how to incorporate smart contracts into an LLC structure to manage that structure and appropriately identify digital assets as representations of value in that structure than I think we can look at right now. The question is, you know, are there fundamental flaws in the framework that would either preclude or over-empower or in a way that's detrimental to the state of Wyoming's business operations, enable things to happen? And those are the concerns where, even if we can't foresee all of the use cases exactly, we want to make sure we're not holding back those use cases, but properly giving legal authority to those use cases that they do identify. And I hope that provides some clarity. I can brainstorm solutions probably to each and every query you've got, but it doesn't mean it's the best way.
Senator Scott?
Madam Chairman, and I've got some more questions on this, but I'm starting to think we're plowing enough new ground here. That one of the risks we wind up with is we put something in here that experience shows just flat doesn't work, or gets out of control, can and is being misused. Is there a way we can craft a sunset date on this thing so that we can force organizations to get formed now to either go out of, have the choice between going out of existence and reformatting their fundamental articles of incorporation and smart contracts to conform with a revised statute, say 10 years down the line, where we've had some experience and found out what we didn't anticipate. Just a simple sunset, I don't think works in this, because you start getting some interest and people would have to have noticed that this would be available. But it might be very useful if we created some things that proved to be monsters we had to deal with or modify. And I throw that to the committee to get you all thinking on it, that there might be something we ought to do here simply because it is pioneering. You don't want to discourage people from using it, but you may need the opportunity to come back later and say it can go on this long, and then you've got to comply with revised statutes, because we had a sunset. Just as a way to, really, I look at this as some extraordinary, interesting experimentation, Madam Chairman, but one that maybe we ought to have a safeguard or two, because I'll bet we learned something that we had no idea we were going to learn.
All right, any additional questions from the committee?
Madam Chairman, a quick response to that, and Mr. Kaufman may have them as well. We do have some protections in here which were built in for those purposes. On page 15, a dissolution event, if there's no actions taken for a year, that's kind of our off the rails approach. If it goes off the rails and becomes unresponsive, we're not going to give it liability protection. And Romanet 5 on that page, if the Secretary of State finds that it's no longer performing a lawful purpose, then the Secretary of State can dissolve that company as well. We talked a lot about kind of the non-responsive nature and making sure that there was the ability to maintain management of the DAO, to maintain the LLC protections under Wyoming statute as being the key to that provision. And if we had changes to the law, it's an interesting question of the expectations at that point. But when you contemplate changes to corporate law, as we do right now, we do that very carefully because we know that corporations are operating under existing law and have based their operations under existing law. So the idea that we would just say, well, there's an expiration to your corporation, that would be a little bit cringy. I think 0 companies would then sign up for a corporation that has a sunset date. I know I wouldn't. I would look somewhere else. But when it comes to being obligated to follow the statutes that govern that debate, again, I think we're in a good place on that, I would say, based on how we treat that as corporate law. But that's where I'd like to hear from Mr. Kaufman and his thoughts.
Yeah, and thank you, Mr. Chairman. And I would just supplement that by saying, and reminding again the committee that in my mind, there's nothing necessarily keeping entities from doing this already. And we have seen in other states, people form DAOs, decentralized autonomous organizations of some sort, again, by cramming them into an existing LLC statute. Interestingly, we have an opportunity right now in Wyoming because we are the only place in the country that has built out the rest of the infrastructure, defining digital assets, defining those other rights that are necessary building blocks to be able to make something like this work. In my mind, again, and one of the reasons that we structured this as a supplement to the LLC is, as I'm preaching to the choir here, we all know we have a phenomenal LLC Act in this state that works incredibly well, and that has served its purpose incredibly well to accommodate different types of uses and creative uses. In my mind, this is one of those new creative uses that just has a slightly different subset of default rules. Really, that's what it is. And to the point Senator Runoff has just made in response to the question, yeah, one of the safeguards we gave the state is that if these things become inactive, if they start sitting dormant, if people aren't maintaining them properly, we have an ability to dissolve them and kick them out. So I do think that's addressed already in some ways, but I completely appreciate and understand the concern.
And just to add one other point there, to the extent that they're member managed, any operating agreement can be, and/or the smart contracts can be upgraded. So any of the underlying aspects of the organization, if there needs to be a change in law, there can be adjustments or other related changes to make sure to accommodate any future developments. But it really, what's happening on the ground today is exactly what Mr. Kaufman said. People are shoving these organizations into existing LLCs. It's exceptionally expensive, cumbersome. The rules are not as clear as they can be under this proposed supplement. And I think that's the really great advantage. We're able to lower the costs of putting these things together, enable a greater range of experimentation. And there's a tremendous amount of experimentation with DAOs now. Just over the past year, the total number of assets that are now in DAOs has grown from just under $10 million to over $1 billion. And if it follows comparable growth rates that we've seen in other forms of technology, I imagine that that's going to be quite large. There's other jurisdictions around the globe that are contemplating how to amend and adjust their corporate laws in order to accommodate these structures, because these are, good folks that just want to manage their affairs, not using just legal agreements, but using software because it's more efficient. They can get things done better. They can get that information available to folks that are participating, and they can account and keep track of things a little bit easier. And that's a huge advantage. That means that you can have the leanest, most efficient organizations possible, and that should be good for everybody involved, particularly with the safeguards that are put in place, where people, where there's opportunities to make sure that this is being done for the appropriate purposes and with the right safeguards.
Mr. Chairman, and I don't mean to monopolize this, but you've got a provision that the corporation can be algorithmically managed with the management vested in a smart contract. At least that's how I read page 11, lines 11 through 15. You can be in any kind of lawful business. Suppose you're in the kind of lawful business, say a securities business of some kind, and you get a cease and desist order from the proper regulatory authority that is objecting to one of the ways that the corporation operates. How do you ensure execution of that order, presuming it's lawful?
Professor Wright, do you want to take that one?
Yeah, I mean, this is an open question, but the smart contract code itself could accommodate such a request conceivably. And if it can't, then there's safeguards in place where it can no longer be recognized as a legal entity. So if it's deemed unlawful, as noted before, then it can be dissolved or not recognized. And the folks that are using this algorithm to organize their affairs, which is primarily the case, will not get the legal protections that they initially were seeking. And that's, I think, the appropriate response there. If you want the protections of a state, if there's certain requirements that a state or court or other judicial body are going to mandate on an organization, then program it in. And this gives an incentive for that to happen. And if not, well, you're not going to be legally recognized. You're not going to get the protections. You're not going to be able to engage in more fulsome commercial activity like a responsible party. And so that's the thread that we're trying to balance. And I think the incentives are baked into the statute such that we can see innovation from developers and a whole bunch of other folks to accommodate these types of requests and needs.
Yes. And another question I have, as I understand, the smart contract is likely to be in some kind of a code. Is that something, suppose you had a dispute where you've got a regulator, and again, say it was a Federal Securities Exchange Commission or something like that, is the regulator, and they need to know what the smart contract does. Can you get into a situation where really the only people that can understand what the smart contract does and will do and foreseeable future circumstances are the people that wrote it, and it may be impenetrable to somebody outside it? Am I seeing things go bump in the night, or is that a risk and a problem?
Yeah, Mr. Chairman, thank you. And if I may, so I think a couple things there. One, and I don't mean to sound flippant, so forgive me if I do. That risk kind of already exists with any technology company that has a code-based product, right? I mean, at some level, those that design the code have a special knowledge that others may not have. The difference here, though, and the protection that we've created is these smart contract platforms are to be made publicly available. And it has to be decentralized in such a way that it's accessible and open, that the members, anyone can access it. Now, does that mean that you individually might be able to get on and decipher that code and what exactly that code means? Maybe you need someone to help you do that. But that's, again, in this context, that's no different than a lot of people need an attorney's help to decipher what an operating agreement ultimately really means in terms of their rights. So in my mind, yes, conceivably, a regulator might need to know what that code is, but it's going to be accessible. And if there is a necessity for a change, and as Professor Wright pointed out, we already have the one fallback catch, and that is if for some reason the smart contracts were executed in a way that was unlawful, this entity doesn't earn or deserve the limited liability protection status of an LLC. So that's already built in. If it's a matter of complying with regulators or changing something in some way or another, the entity has to respond just like any other entity would, right? There would be, you know, there would be a responsibility of the entity to respond. And in the same way as any other entity, these will have designated registered agents, which would be a point of service or contact that have to be, you know, located physically within the state. So again, that's sort of a roundabout answer to try to address all of the concerns you raised there. But in many respects, I view this as, again, not a departure from the way that we currently do it with LLCs. We're just creating the default structure.
Can I just one other point there? Also, the smart contract code up until this point in time, it's becoming increasingly standardized. So in different parts of the blockchain ecosystem, there's smart contract standards that have emerged organically. And that actually makes it easier for people to understand the mechanics of it. So you could imagine over time, even though it's represented as software and it's written in a language of software, people will understand it just because it's familiar to them and has been widely used in other organizations. And that actually can lead to more clarity and simplify things further. If it ever went to a regulator or a court, beyond the great analogy that Mr. Kaufman just had with regard to legal language and lawyers, an expert could always be enlisted in order to understand the mechanics of what that code does and how it operates. But I do think that that's, you know, in many ways will over time become less and less of a concern if we start to see different libraries or sets of smart contract code become standards. Once something becomes more standardized, it's easier for people to understand what's going on there without the need for, you know, anybody else to weigh in.
Madam Chairman?
Senator
Or Mr.
Roberts.
Chairman? Mr. Chairman. Mr. Chairman, one more thing I wanted to follow on with is just to emphasize the concept that you can already do smart contracts right now. You can already make these arrangements and you can hide that code and you can do it on or off the blockchain. You can do anything you want with regard to those concerns that are being expressed. At the same time, you can do shady things with LLCs right now. You can create an LLC. You can meet in a dark room, smoke cigars in that fluorescent light lit basement I mentioned earlier, and do all sorts of nefarious things.
That's not shady.
It depends on what you're doing, Mr. Chairman. So we can't solve for nefarious intentions. The beauty of this, though, is that we're bringing together two things that are unquestionably already being done. And we're trying to take the DAO structure and we're trading the LLC protections of the state for transparency. And that's really what we're doing here. We're inviting companies, come do your business in the state of Wyoming. If you operate transparently, we will provide protections of a limited liability corporation. But the moment you don't act responsibly and don't act like a limited liability corporation should, we're not going to continue to give you that protection. And that's built in, and that's the concept that we're trying to provide. So again, I wish we could solve for all things. That'll be a challenge, but we're trying to make sure that we've got sufficient tools in place to remove that protection. And it's very clear and unambiguous that the Secretary of State has pretty unilateral authority to remove that limited liability protection if he finds them to be operating unlawfully. I hope that provides a little bit of confidence there. Thank you.
Thank you. Further questions? Senator Nethercott.
Mr. Chairman, can we just take a minute and appreciate Mr. Kaufman's face when discussing cigars in the basement? Clearly, he is not an elected official.
I am. I saw it. Okay. Thank you for your testimony.
Thank you.
And who do we have next? Do we have anyone in the waiting room on this one?
Mr. Chairman, we don't have anyone with their hand raised at the moment for this bill.
Okay, and do we have anybody from Secretary of State's office here? Just curious.
No, but Mr. Chairman, we did hear from the Secretary of State's office during the interim on the blockchain.
Correct.
And Chairman Rothfuss, could you see if that mic is off?
None of them are on. So I'm not sure it's like.
And I would just say, if there is anyone in the waiting room online, if you would raise your hand right now. I don't think there is.
Okay, with that, I don't think we have anyone in the room. Public testimony is closed.
Move the bill.
Bill has been moved. Discussion.
Mr. Chairman.
Senator Scott.
Fascinating proposals I've seen down here. I think we're getting very creative. I suspect we're going to have to modify it down the road. I would like to see some kind of a sunset provision, but I can't think of one to write that wouldn't discourage the use of it. And the use of it's what's going to teach us where we need to do things a little differently. So, Mr. Chairman, I think we're taking a significant risk going forward with it, but I think there might be quite a payoff as well. So.
Madam Chairman?
Senator
Mr. Chairman,
Rothfuss.
I'm sorry. All right, I'm going to stick with Mr. Chairman here.
I'm the one with the cigar.
You're here now, exactly. Mr. Chairman, the good senator is exactly right. There's no question we are coming back with amendments on this statute if we pass this bill a year from now. And this will be topic number one for Blockchain Select Committee. Will be, keep working on DAO legislation, because we will get feedback immediately. We will get a deluge of it once this is on the books, and we'll learn more, just as we did with the digital asset custodyship. Boy, that caught the world by fire. And we received feedback from all over the planet, not just the United States. And we've incorporated all of the wisdom that we received, the best advice. We've built a better product, and that's made us even stronger. And we'll continue to do that. We've got another bill coming down from the other chamber that's passed that will be working in the Senate in the not so distant future. So it's essential that we stay on top of it. I think we need to keep our eyes open, look for those concerns, work together, this committee and the select committee. But again, this is an opportunity for leadership that, as Senator Scott mentioned, there's a lot of possibility here. If these entities are domiciled and they end up holding billions of dollars of assets that are domiciled in Wyoming, generally that's a pretty good thing. And we know that we've already attracted companies that are working with billions of dollars of assets that certainly weren't going to be in Wyoming without some of the previous new provisions we put forward in that leadership position. So I welcome that. And Madam Chairman, one other point I would make Mr. Chairman, one other point I would make as the bill is being worked. I did distribute an amendment that you should all have a copy of. And when the time is appropriate, I'd be happy to work with you on that. That might be now, it might be later, but that's up to you, Mr. Chairman.
Senator Rothfuss, I think we're at the point that we're ready to work the amendment in.
Excellent. Mr. Chairman, I'd invite Mr. Kaufman back up here to talk a little bit about what we're doing here. But this again gets to how unique I think the work on our blockchain select committee has become, where folks from all over the country that are working with our working group. And even though we had Mr. Wright and Mr. Kaufman here, I think we had about 10 people on the working group from all over the country that met by Zoom, probably a half a dozen times. And one attorney that is an expert on both UCC code and corporate law that read our draft when we requested reviews of our bill draft raised this, which was an inconsistency, kind of, in our digital asset custodianship, as we have elucidated under a mapping to the UCC with this new proposed legislation, where it was somewhat unclear how DAOs would be handled as to whether they would be digital assets under Wyoming statute or traditional LLC ownership assets. And this just provides the clarification of a default position and an allowance to accept the alternative. And I'll let Mr. Kaufman provide a little more background.
Mr. Chairman, thank you. The simple explanation is, so generally speaking, for UCC purposes, LLC interests are considered general intangibles. And that's kind of the default standard. The concern here that was raised by this UCC expert, which I think was valid, is that leaves the possibility that someone could try under our statute to define that LLC interest as something else, like a digital security or virtual currency, to try to game that a little bit. So the suggestion, which I think was a very good one, was just a simple clarification that unless the LLC purposefully opts in to be characterized as a digital security or virtual currency, the default's going to be consistent with the underlying LLC Act, that it's going to be treated like a general intangible. So this single sentence addition is just intended to bring that clarity, again, consistent with the underlying LLC Act.
And one more point of follow-up, Mr. Chairman. This particular expert was enthusiastic about the idea that a DAO could name itself a digital asset under Wyoming statute because of the alternative treatment as direct custody ownership, and there were some potential values there. And of course, we're the only state in the country and jurisdiction in the world that has a fully fleshed out ownership and property system associated with digital assets. So if there were an entity that wanted to do that, then we would be the only place where that would be an objective that could be accomplished. So the suggestion then and the consensus of this working group was, let's make sure both options are on the table. And then we really just went back and forth a little bit about what the default was. And we decided that in keeping with our typical statutory approach, we would make the default what it is for a traditional LLC. And that if you were sophisticated enough to know the difference, that you could opt in through your articles to be treated under Wyoming statute as a digital asset.
Very good, thank you. Questions? Senator Scott, do you have one?
Mr. Chairman, I've got a general question just to dispose of the amendment.
Okay, thank you. Any questions on the amendment? Someone want to move the amendment?
So moved.
Okay, amendment's been moved. I think we're at a question point. All in favor, raise your hand. Amendment is passed. We're back on the bill. Senator Rothfuss or Kaufman, I'm not sure what. Scott.
Mr. Chairman,
Senator Scott.
if I may ask one general question. We pass this and we start getting them. Are we going to need to take steps to educate our new Chancery Court and its judges on some of these so that we develop an expertise in how to handle that is unique in that respect too? And I'm thinking specialized training for the judge and some of the people involved.
Senator Kaufman, Mr. Kaufman. I
Thank you
continue to
again,
make you a
Senator.
senator. You'll have to get a cigar.
I can handle that. Mr. Chairman, thank you for the question. So one step ahead of you, Senator. I said I'm one step ahead of you on that. We are developing some materials already. I serve, as appointed by the Supreme Court on the Chancery Court Committee, and we're already developing a list of some resources for the future Chancery Court judges in all of these respects. And, you know, if I can just address that even a little bit more broadly, again, to your point, Senator Scott, I mean, we've created something incredible here in Wyoming that I think a lot of people just don't even realize yet. This digital revolution is occurring like a tidal wave, and it's coming. And people are very excited about the statutory structure that we've created in Wyoming for these digital assets. And when you combine that digital asset legal infrastructure with the banking and custody infrastructure that we've now created that's being set up, and then you create these new ways for entities to interact using those, it's pretty incredible. And I suspect we will have instances where we'll have to pave the way with respect to some legal disputes. That's to be expected. But we've built the building blocks that we're now just kind of adding to them. And it's pretty impressive to see that validation, as Senator Rothfuss said, from lawyers and technologists from all over the world.
Thank you. Further questions, committee? Senator Nethercott?
I think public comment's closed, so we're on the bell.
We are.
All right. Are we ready for a roll call on the bell?
Unless you had a comment, that's where we're at. We're working through it. So believe we are to that point. Roll call.
Senator Boner. Senator Case. Senator Nethercott. Senator Scott. Chairman Driscoll.
Aye.
Mr. Chairman, Senate File 38 passed as amended with 5 ayes.
Thank you.
Mr. Chairman,
A
thank you,
huge,
committee.
huge thank you to Mr.
Oh,
Kaufman
holy cow, yes. Absolutely.
and Senator Rothfuss. Smart contracts this is the cutting edge, folks, and they're out there everywhere else, but not in the United States, but outside the United States, they're in place and running. So this is a key piece in our box, and I appreciate you guys getting it across the line. Thank you.
Thank you, Chairman. Thank you.
Senator Cooper, would you like to? We did not tear your bill up when you were gone. We are on Senate File 126, Real Estate Subdivision Easement Requirements. Senator Cooper, you have the floor. Proceed.
Thank you, Mr. Chairman. Committee, apologize for not being here early this morning. I had an unintended conflict that, well, no excuses, I was late. Excuse me. Senate File 126.
Real quick, can you identify yourself? We've got to do it for the
I'm sorry?
online. Start by identifying yourself and your Senate district at the start.
Oh, I'm sorry. Ed Cooper.
Perfect.
I'm learning. Ed Cooper, Senate District 20. Thank you. All right. Senate File 126 is a fairly simple thing. It's I'll give you a little backstory on it first. We have a gentleman in the district who is attempting to put in a subdivision, a small subdivision, but nonetheless, it's more than the 5 lots. He has a piece of property that he's working with that he owned it all at one time. He had a well on one side, a good flowing artesian well. And his subdivision growth is on the south side of the property, and he sold the piece in the middle off several years ago. When they sold that piece off, they did an easement across it. And that easement is only 8 foot wide for the water line. He has since went back and replaced that water line and utilized that 8 foot easement, put a bigger line in, moving forward with this. But when the county planner got ready to approve his subdivision plan, that easement showed up as 8 foot, and the statute is very clear. It says that it has to be a 20-foot easement. So he had to reject that plan, and rightfully so. So what we're doing with this is asking for the commissioners to be able, or the board to be able to give a variance on that at their discretion. It's just both good and bad. There's been a lot of work put into these subdivision bills over the years, and they are like they are for a reason. This one was either an older easement. I can't tell you exactly the date of it, but for whatever reason, it was only 8 foot wide. So the only issue he has right now on his whole subdivision, he's done everything else very properly. It's just the width of this easement. So what this bill does on page 2, line 14 through 18, it says, it inserts a paragraph that says, except that the board may accept copies of a binding easement of a width less than 20 foot if the subdivider demonstrates to the board's satisfaction that the easement is adequate to protect the safety and health of the public. He's basically already done that because he's already replaced the line across it without stepping off of his 8 foot right of way. Unfortunately, we're in a situation where maybe they need better fences because good neighbors make good fences. But this is where we're at, and this is what we're asking for, is just a simple discretion of the board to approve this right of way of less than 20 foot. He's demonstrated that he can do it safely and properly. And again, that's his only holdup on the entire subdivision. So with that, that's Senate File 126.
Thank you, Senator Cooper. Questions for Senator Cooper? Senator Boner.
Okay, thank you, Mr. Chairman. It seems like the assumption here is that current minimum 20-foot easement is there for safety reasons. And
I'm sorry, Senator Broner, I'm not hearing you.
Okay, can you hear me now?
Yes, sir.
Okay, there we go. So it seems like the assumption is that 20-foot easement is there only for safety reasons. Can you just give a little bit more background as to why that current restriction is in statute? Normally, I would think that'd be left to if it's a private property owner, that they'd just be left to negotiate whatever width of the easement would be proper. And so I'm just wondering if you have a little bit more background as to why we have a minimum in there at all, and if it might be more appropriate just to strike that requirement. But like I said, mostly when you talk about an easement, you want to minimize the amount of, as the landowner, you want to minimize the width, and just based off of what the operational needs are to actually maintain whatever the utility is. So just a little bit more background on the purpose for that 20-foot restriction to begin with, because I just don't see the reason to have it in the statute, but just a little more background.
If I'm asking your question, I'm still having a little trouble hearing you, sir, but excuse me, Mr. Chairman. Senator Boner, I'm having a little trouble hearing you yet, but I'm understanding you'd ask that you're saying that this should have been negotiated with the neighbors. Is that correct?
Mr. Chairman, why is there a 20-foot easement at all? Why is the minimum requirement in statute?
Excuse me, Mr. Chairman, Senator Boner, I can't tell you why the requirement is for a 20-foot easement, but that is the statute. The 8-foot easement that's there is adequate to do what is needed for this particular line. So
I'll actually follow up a little on it. I think I can lead into it possibly is, have they anticipated, obviously easements are permanent and the subdivision's permanent. Have they anticipated how they're going to get in to fix on an 8-foot easement? When you look at a backhoe and a pile of dirt and staying in on it, and that's mine, is have they anticipated or put in the easement something that says that they can get outside of it for repairs or replacement? Because I've seen this happen in my county. We actually had a phone company truck that managed to have all its tires get cut by a rancher that was stuck in the pasture on an easement that was narrow. So can you answer if they maybe have this or have thought about a provision for it?
I don't have the direct answer to that, Mr. Chairman, but I can get that answer for you, sir. But in my opinion, this 8 foot was probably an oversight to the rules when the easement was built. And they've attempted to negotiate a wider easement. The current owner of the property that is crossing, his solution is you just need to buy it back for me. And the price is roughly double to what he bought it for. So that's not working. They've looked at drilling an additional well. Those wells are relatively deep and quite expensive, a couple $100,000 for a well of that type in that area. So they're looking for relief in this matter.
I get that really well. Are we going to encourage more easements that cause the same problem by this bill?
And no, they will not need, if you're asking if, I'm sorry, sir, they're asking if
I'm
they're
asking
going to need
if we pass
additional.
this bill, if we're encouraging people to do more 8-foot easements
Yeah,
out there.
there's not a need for additional easements. Everything else will go in a different direction.
No, it's forward. We're putting in statute, and I'll go back and forth with you. I'll formalize just a little. But in this bill, once we've passed it, now we've allowed that exception to come into law. It's not just your case, it's going to be law, and we can go into them on new ones. And I'm suspicious
Okay.
if we change it from 20 to 8, when we're doing subdivisions and pieces, those easements discount the value of your property. Are we going to create an attractive nuisance that we have a whole bunch more new 8-foot easements out there?
In this case, no.
I get this case.
But in future cases, again, there's a reason that these subdivision laws were developed the way they were. It's unfortunate that this is where we're at, but I'm just trying to address the current problem, sir. So.
Perfect. Thank you. Further questions? Senator Cooper. Hearing none. Do we have any testimony either online or in the audience?
Yes.
Ms. Kaiser.
Thank you, Mr. Chairman. Good morning. My name is Sherilyn Kaiser, and I represent the Wyoming Realtors. And just wanted to make our comments very brief, that just to let you know that the Wyoming Realtors support this bill. We support the county's ability to regulate the development of well-planned subdivisions. And we feel that this bill merely just gives the counties an option. So we encourage your favorable consideration. And I stand for any questions.
Question for Ms. Kaiser. Seeing none, thank you for your testimony.
Thank you.
I believe we have Commissioner Willicks in the waiting room. Welcome. Good to see you again, Commissioner Willicks.
Good morning, Mr. Chairman. Thank you. Jim Willicks, Converse County Commissioner and President of the Wyoming County Commissioners Association. The Commissioners Association is in favor of this bill, mostly because it gives us options, and we're always in favor of options. But I would note, as the chairman pointed out, I would hope that any county would use it very, very judiciously, because creating narrow easements is something that we did not encourage, but there are times and situations which it makes sense. And so by having that option in statute, we at least have the ability to look at unique situations that less than 20 feet would be proper. But I do believe the default stays at 20 unless they can prove otherwise. And I believe that bar should be relatively high because of the future expansion. If I may, Senator Boner's question about why it's there, it's really about both construction and maintenance and future development. If you stack subdivisions beside each other with multiple landowners, or the same landowner doing multiple subdivisions, which is a little bit similar to the way I understand Senator Cooper described this, you need to make sure you have adequate easements in place. And we have ran into times where that has happened more with roads than with utilities. But it is much easier to start with an easement that is adequate up front than it is to have it too narrow and try to correct in the future, which is almost impossible. So again, stand in support of this, but hope it will be used judiciously, and stand for any questions.
Questions for Commissioner Willicks? Thank you for your testimony. Appreciate your service.
Thank you, Mr. Chairman.
Any further testimony? Any further testimony? Public testimony is closed. Thank you, Senator Cooper. Committee, what's your pleasure? Bill has been moved. Discussion on the bill.
Mr. Chairman,
Senator Boner.
I just have, and just want to make sure we got our bases covered because like I said, it's as much about access as it is about safety. And so I guess I'd propose an amendment on page 2, line 18 that go along the lines of after public, add the words and provide adequate access for the maintenance of the facilities. And we can have the discussion whether, making sure you have proper access to it for maintenance qualifies as protecting safety and health of the public. But I just want to make sure that if this is about giving county commissioners flexibility, that they're, we don't just focus on one element that goes into easements and focus on, the other important element that at least as I'm familiar with it.
Discussion on the
Mr. Chairman, if I may.
Senator Nethercott.
Well, looking at this bill, I think that's a fair amendment, but just on the concept of the 20 feet, looking at other communities across the country just randomly as I was able to find, this is actually not uncommon at all when it relates to these utility easements, that most of the ones that I found online provide that 20 feet and then exceptions are allowed for less than. So this is common, I would say, this concern and this fix. Maybe not as exciting as we had hoped for the morning.
Very good. Further discussion on the amendment. Further discussion, question called, all in favor of the amendment, raise your hand.
Aye.
The amendment is passed. We're back on the bill. Further discussion on the bill, committee.
Mr. Chairman, I
Yes.
mean, could Senator Boner repeat the amendment one more time to make sure I have it correctly?
He can.
Okay. So page 2, line 18, after public, insert and provide adequate access for the maintenance of the facilities.
Got that? Okay. We're back on the bill. No further discussion. Question called on the bill. Roll call.
Aye.
Senator Case.
Aye.
Senator Nethercott.
Aye.
Senator Scott.
Aye.
Chairman Driscoll.
Aye.
Mr. Chairman, Senate File 126 passed as amended with 5 ayes.
Thank you. I think we're going to go ahead and start on the next bill. We've got a little time and it's going to run over. Are you prepared, Senator Beitman, to take off? So it's 9:30. We're going to stop testimony about 9:55 or so on this so everybody can get up in time. So you're not in any hurry. Just take your time, work your way through the bill, and we'll continue it again on Thursday. So
All right.
with that, Senator Beitman, you have the floor.
Thank you, Chairman Driscoll, esteemed colleagues. I'm Senator Beitman. I represent Senate District 21. I'm here to present to you Senate File 145, runoff elections. Purpose of the bill is to ensure that the winner of the primary election for federal, statewide, and the state legislature has the support of a majority of voters. Runoffs are common in areas of one-party rule, and they are helpful when there is a large field of candidates. Wyoming is predominantly a Republican state, as you know, and often has many candidates run for federal and statewide office. This bill will help voters feel more confident in the election process and will provide the winner with a mandate, something that has been lacking at times when you can actually have a winner whose opponents collectively receive more votes than the winner under our current system of winner take all. It is often argued that this method results in better candidates moving on to the general election with broader support and who are more appealing to a broader base of voters. So that's the why. And I'll walk through key provisions of the bill. The bill has 4 key components. As you'll see on page 1 and on to page 2, section 1 establishes the runoff election if no candidate receives more than 50% of the vote Second key point to take a note of is section 2. It changes the date of the primary election and amends related dates. And why do we need to do that? Well, my original bill draft had everything going kind of in kick to put the runoff on the date that the primary is on currently, which is the third Tuesday in August. And then I wanted to move the primary up to say late June, early July, shorten that time frame. Well, after talking with my county clerk, that was completely unworkable. And talking to a former good senator of ours, who's now the treasurer, he's also worked on this for many years, and he gave me his cliff notes, and I kind of started with that. And he told me it's best to start at the general election and work back because there's so many dates that you have to take into account with military and overseas ballots. So that's what we did. So what we did was we kept the runoff election on the third Tuesday in August, if needed. And it actually moved the primary up to the first Tuesday in May. It's actually the Tuesday next following the first Monday in May, but I like saying the first Tuesday in May. So that's where it moves it to. There's conforming amendments throughout the bill. As you can see, just flipping through the pages, it's going to go into different sections of the election code to adjust the dates and adjust all the election code to conform to our moving the primary up. Section 3, if you move to page, let's see what page is that? 17 of the bill. It's a good little piece I want to point out to your attention. It states that the Secretary of State's office and the Wyoming County Clerk shall confer on the scheduling and timelines required by this act. They may make a report to the Joint Corporations Committee with the recommendations, and the committee shall consider any recommendations and or changes during the 2022 budget session. So it kind of gets everybody together, takes a look at this bill, and gets everybody's input going forward and makes it workable. And if there's any changes that need to be made before the next election, that it'll be brought to your attention in the interim. And some common questions regarding runoff elections. There are currently 10 states that have some sort of a runoff election. Some have lower thresholds than the majority of votes. For example, some are like 30% plus one, 40% plus one. How many races would affect in the legislation and the legislator races each cycle? I looked at 2018 and there would have been possibly 3 runoffs in the state Senate races and 2 in the state House. Before that, going back, there was very few races that would have triggered a runoff. So they would be less common in the state legislative races, more common obviously in the governors and Secretary of States and the federal offices. Looking back at the past data, in 2018, the governor's race, the winner had 33.4% of the vote in a race with 6 candidates. In 2016, the U.S. House race, the winner had 39.9% of the vote in a race with 9 candidates. This is the big one. The 2014 Secretary of State's race, the difference between first and second place was 33.53% of the vote or 33.17% of the vote versus 31.53% of the vote in a race with 4 people in it. So the runoff could have really made a big difference in that race. The top 2 were neck and neck, virtually tied. And then the bottom 2 just took votes away from the top 2, and a runoff could have changed the outcome of that race. 2014 Superintendent of Public Instruction won the race with 35.74% of the vote in a 3-person race. And we'll hear a little bit about cost. I'm sure I got a fiscal memo from LSO. And the number's not quite large, and it is a small price to pay for a well-functioning democracy, typically less than $1 per vote. So we have 302,963 registered voters. Basically, the fiscal memo amounts to about 60 cents per voter to do a runoff. And with that, Mr. Chairman, I know we're short on time and there's some folks that want to testify. I'll stand for any questions, and thank you very much for your time.
Mr.
Senator
Chairman.
Nethercott.
Yes. Why are you bringing this bill now?
Mr. Chairman, Senator Nethercott, I thought I explained that in my opening remarks. This bill, yeah, as you know, I've come before you guys 2 years in a row, 3 years now, with election-related bills to try to fix our election process. Our primary elections in the state of Wyoming are not making anybody happy. And the last tack I took was to try to stop crossover voting, because that's a problem in the state of Wyoming. When we have a one-party state, everybody wants to play in the Republican primary, even though they're not Republicans. This is a different angle. It tries to ensure that the winner has a mandate and the party can get behind their candidate. That way you don't have, the winner in some cases with less than 40% of the vote, sometimes in the low 30s or high 20%. So you've got 70% of the people that didn't vote for the winner. People understandably are frustrated with the current process. And so this bill is aimed at getting our primary elections to a point where more people are happy with the outcome, and more people are satisfied that their voice was heard. Thank you.
Mr. Chairman. Two sets of questions, one regarding minor parties and one regarding the who can vote in the runoff. Let me ask the who can vote in the runoff. We have same-day registration. Frankly, I don't know how far the primary one goes, but it was that way when I was growing up in this state. So it goes way back. Will there be same-day registration permitted in both the initial primary and the runoff? And will people who fail to vote in the initial primary, say they were out of state and didn't bother to vote absentee, will they be able to vote in the runoff?
Mr. Chairman, on page 7, at the bottom of the page, lines 16 through 23, and then on the page 8, it describes qualifications and temporary registration for the runoff. It says in paragraph F, only persons registered with a party affiliation to vote in the applicable partisan primary election, including those who registered at the polls at the primary election, may vote in the runoff election. No person shall change his party affiliation to vote in a runoff election from that under which the person was registered at the time of the primary election. No person shall vote in a runoff election if the person no longer resides in the applicable jurisdiction. So if they voted in the primary and then moved out of the district, this only applies in statewide or state legislative races, if you choose to keep that section in the bill. If I voted in my Senate district and then I moved to a different Senate district, but my district has a runoff, I would no longer be qualified to vote in that runoff election if I do not reside in that district. Statewide, federal, it doesn't matter. You're still in the state of Wyoming. Unless you move out of the state, you'll be qualified to vote.
Senator Nethercott. Okay. Senator Scott, follow up.
Mr. Chairman, not a follow-up, but a different question.
Proceed.
Mr. Chairman, what does this do to the timing on the minority parties and when they have to want to get candidates on the ballot? Name their candidates.
Mr. Chairman, I might have to defer to the county clerks on that or the Secretary of State's office. I know it's in the bill, but I don't have the page on it. I know it pushes all the dates go pushed back into January now or February. I know the primary filing period is typically in May. That gets pushed to the end of February. And so I'm sure the candidates for the minor, all the parties will be the same.
I've got a little follow-up on that. And then you're into legislative sessions, back to legislature. So you're there, and that's, I'm not plus or minus, just a fact. I guess my question is, with these early dates and somebody loses in the first primary end of it, does this leave a window open with these early dates for them to switch parties and get on the ballot on the other side?
Mr. Chairman, I think we have a sore loser law in Wyoming that prevents people from if you lose in a primary election from running for that same office.
Okay, very good. Great answer.
Yeah, Mr. Chairman, just a technical question. The effective date is July 1st, 2022. Just want to make sure you're envisioning this actually going into effect if it becomes law in the 2024 election cycle. Is that correct? It just seems a little awkward to have it. I mean, if the idea is to have the primary in May and then the runoff in August, to have the effective date be right in the middle of those two times would be awkward if your expectation is that it's going to be in the 22 election cycle. So just a little bit of clarification there.
Mr. Chairman, that's a great catch, and I did not notice that. I was so wrapped up in the Section 3 language, thinking that was a great idea, that I overlooked the effective date. It does say, except as provided in subsection B of this section, the act is effectively immediately. So we'll take a look at that, and I'll get a better answer for you. That might need to be tweaked later.
What's your intent then? Is it to be in the 22 election cycle or the 24?
Mr. Chairman, I'd like to get this rolling for the next election cycle if possible. Thank you.
Welcome.
There we go. Green light. Excellent. Thank you, Mr. Chairman. Good morning, committee. My name is Kai Schoen, the election director in the Secretary of State's office. And with regard to this bill, our office does not have any position on this bill, but has some information for the committee. And I do want to give the bill drafter credit, Senator Beitman, for working with the county clerks as well as our office, as well as others that have been instrumental on that bill to try to work out dates. There's so many moving parts, as we've already heard. For example, the certificate of office is up for election. It accommodates that. The candidate filing period accommodates that, as well as a 45-day period to deliver absentee ballots to our UWCAVA voters. So it does incorporate all of those timeframes, and I'll speak to some other timeframes in a bit. And as Senator Beitman mentioned, there is a fiscal impact to our office, and the amount of that fiscal impact to our voter registration system. And sometimes I feel like a broken record because I talk about our voter registration system almost in every election bill. But for us all to understand really the backbone of our voter or election process really rests on our voter registration system. Almost every piece of it, it has to move with that voter registration system. And so the impact is a one-time cost. It'd be $166,408. And that's simply to make modifications to be able to incorporate a new election method, such as a primary runoff election. It would also have to take into account functionality to generate the type of list of those that would be eligible for that election, as we've already discussed, those that were eligible at the time of the election, and those that registered on the day of the primary election, and to remove those that may have switched their party. So that currently is not a function we have, but would have to work with logic and whatnot to get our system to accommodate a list, so we have a clean list to have that runoff election in accordance with this bill. This is more of a minor fiscal impact, but it does affect our office because we're in charge of delivering absentee ballot envelopes to the counties. And so taking our numbers from the 2020 primary election and applying it to a potential statewide runoff election, it would roughly be about $17,500 for those absentee envelopes to accommodate an additional election in an election year. And we've already discussed this as well, but over the last 10 years, so the last 6 election year cycles, given just the statewide election runoff, we would have had 5 runoff elections that would have been statewide. And so that comes into play here in just a little bit. And I know there might be members from the County Clerks Association that will also talk about their impact. But their impact is extremely more than what our office has. And large in part because elections generally are being conducted at the local level. They're the ones that have been paying for these elections. It doesn't specifically say who pays, but that is how we've been doing things. And so based upon the 2020 election, again, the primary election alone, when you take into account the ballot coding, the printing of ballots, when you take into account the training of your election workers, or just paying for your election workers, acquiring facilities to serve as polling places, you're looking at roughly $1.1 million to conduct that piece of the election. And there may be more information on that, again, if the county clerks speak to that. But I think it's important, I think it's important for the community to know that elections, they really are, expensive, the whole of it together. There is cost to that, and for good reason. They're important. So we want to make sure we do it right. Again, all the dates proposed by the bill, they really appear to be in pretty good shape. They seem to ebb and flow with one another. There is one component that I wanted to bring to the community's attention. I don't know if we've thought through this, but it's been most recently that I've been thinking through redistricting. And so it's kind of fortuitous that this bill is before us now, because redistricting is happening just next year. And I know that it's the duty of this legislative body to determine those district lines and pass those for the 2022 election. And when I think of that, you may have heard in the news about the U.S. Census Bureau letting states know that they're behind. COVID-19 certainly caused various delays to getting that data pushed out to the states. Their target date was actually the end of this month. It's not going to happen. We're going to see that sometime in September is what we have been promised. And so I bring that to everyone's attention, because I know in the interim that's going to take place after the session, you all are always working with those boundaries and playing with different ideas and trying to get something in a good place prior to the session come 2022, so that you can roll through that and get that passed and in effect for the 2022 election. I would like to address, so that we're all on the same page, that with redistricting, there is a provision that is within our law that does accommodate candidates that may have been drawn out, if you will, or drawn in, however you want to say it, if their district has changed. So long as they reside within the county of which that district is in for a year preceding that election, that still qualifies for residency. So candidates, in essence, can be covered. It doesn't take into account voters who will be drawn into different lines. And so what I mean by that is, once the redistricting plans are in place, it gets passed on to the counties. They have a lot of work to do. Again, it does touch the voter registration system, not from a fiscal impact way, but certainly administratively, and a time restraint on the counties to get these various address, what we call it the address library. So these different address ranges need to be reworked and reassigned, broken up, merged, all kinds of things to make sure they're in the correct legislative district, so that they can participate in the election in the correct district in which they've just been redistricted to. And in the bill, the primary election, and this was on purpose and for good reason, is in May, and that's to accommodate all the other timeframes that happen after that. But of course, that's a very small window when we're talking a year of redistricting for the counties to get this data, especially when, as a state, we're not going to get it until September. And so that just brings more of a restraint to 2022 than it will for 2032. But nonetheless, it's something I think really needs some more consideration. One other piece that I also wanted to mention is the campaign finance component. That's not addressed in here. And I apologize for not even being able to bring this to Senator Beitman. But it's something that was just most recently thought about. Wait a second, we're missing a piece here, and that is the campaign finance element. Our laws strictly speak to the primary election, general election, and special election in Chapter 25. And so I'm not sure how that would play out, but I think that needs to be, I would recommend that it be a part of this bill should this move forward. Kind of skip through my notes here to be conscious of time here. And so I think I can keep my comments to that and would actually entertain any questions the committee might have for me.
Question for Sean.
Mr. Chairman.
Senator Scott.
Mr. Chairman, one of the things that I've disliked about the possibility of a runoff election is the timeframes. And am I right in thinking that what really drives the timeframes is the federal requirements on the overseas voting? So that, Mr. Chairman, is my first question. And my second one is the other things I think are under our control. Used to be states that had runoff elections would do it in 2 or 3 weeks after the primary. And would it, if we confined ourselves to, say, the state elected officials, or even just to the governor's race, could we ignore then the federal rules because they wouldn't have the authority to apply them to those, and go ahead and have a much shorter timeframe election that wouldn't require us to move the dates the way this one does?
Mr. Chairman, Senator Scott, excellent questions. Thank you for asking those. Many of these timeframes, they have to consider the 45-day federal deadline for UOCAVA voters. And this bill does that with the May primary election offset with the August, runoff, or when we typically have our primary election today. So it does take that into account. Large in part, our elections are driven by those dates. If we were to remove federal contests from the runoff election provision in here, we still have our state statutes. We've kind of brought those up to mirror. Yes, Senator Scott, absolutely. But currently as is, that is, we have a 45-day delivery date of absentee ballots as well for statewide elections.
Mr. Chairman, I don't necessarily think, I think we could probably fix the state laws and by sticking to the federal candidate, sticking to just the statewide things, I think we'd have the authority to do that. But that's something to explore further, Mr. Chairman.
Thank you. Mr. Chairman, my question is, how big a lift is it to make campaign finance conform to this bill and bring it in?
Mr. Chairman, Senator Scott, of course, it would have an impact to our online campaign finance system because we'd have to accommodate, again, another election. As far as statutorily, it could be as simple as simply adding in primary runoff election.
I'm thinking. So, Mr. Chairman, most of that is about reporting and dates of reporting, and it seems like we ought to be able to just accommodate that. And the bill title, we ought to be able to just bring it in here. I bet we could. Thank you. No, that's it, but we need to make that match.
Further questions, committee? Further questions? Thank you, Mr. Sean. We'll adjourn. We will start with County Clerks Association or clerks when we come back on Thursday. So